Good morning. Today is Tuesday, October the 9th, 2018. It's 10 a.m. It is my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Mrs. Bohannon, would you please call the roll?
Dennis Bridges.
Here.
Mark Cothran.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Mrs. Bohannon. First order of business is the adoption of today's agenda.
Move that we adopt the agenda as printed. Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer to adopt the agenda as presented. All in favor?
Aye.
We move from there into the approval of the minutes from the June 20th, 2018 meeting and the August 14th, 2018 meeting. I think most of you have had the June 20th minutes. You've probably just received this morning the other minutes, so we'll take a minute to make sure that you've had a chance to review those. Are there any corrections or additions to the minutes?
Motion to approve the June and August minutes as presented.
Second.
I have a motion by Mr. Shackford, a second by Mr. Bridges to approve both the June 20th and August 14 minutes. All in favor?
Aye.
All right. At this time, I'll call on Ms. Sherelle Hooper, the Assistant General Counsel of the Regulatory Boards Division, for our rulemaking hearing.
Good morning. This rulemaking hearing is called to order. My name is Sherelle Hooper. I serve as Assistant General Counsel for the Department of Commerce and Insurance, Division of Regulatory Boards. Would the agency representatives who are present please introduce themselves for the record?
Mr. Bohannon, will you please call the roll for him?
Here.
Mark Cothran.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Thank you. It is Tuesday, October 9th, 2018. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Room 1B of the Davy Crockett Tower, located at 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules the Tennessee Board of Funeral Directors and Embalmers has made public in order to clarify the examination and grading procedures, adjust the fees for a number of licensees, require a submission fee for specialty forms to be reviewed, establish parameters on re-registering for apprenticeships, establish 90-day time limits for completing various applications for registration and/or licensure, specify indicators regarding fixed places of business devoted to the care and preparation of dead human bodies, specify new requirements related to the care and preparation of non-human remains, clarify the new in-person and/or virtual continuing education requirement, and add the option of obtaining continuing education credit by attending a regularly scheduled board meeting. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which will be the effective date. Those members of the public wishing to speak should place their names on the sign-up sheet in order to be provided an opportunity to speak. The sign-up sheet is located at the table to my right near the exit door. Only those who have signed will be permitted to speak. Oral comments will not be accepted from any person whose name does not appear on this sheet. Are there any persons present that desire to offer oral comments but who have not signed the sheet? For the record, the sheet is being signed by members of the audience at this time. Is there anyone else present who would like to offer oral comments but has not signed the sign-up sheet? Seeing that there are none, I will draw your attention back to the table near the exit door. There are red line copies of these rules on that table. There are additional copies left at this time. This is required pursuant to a new law that was passed. The notice of rulemaking hearing included the entire text of the proposed rules and was published in the July 2018 edition of the Tennessee Administrative Register. Mr. Gribble, what additional notice was given to the affected individuals or groups?
On August 1, 2018, a notice of public rulemaking hearing was sent via email to those signed up to receive electronic notifications from the board. I emailed a copy of the notice of rulemaking hearing form along with the electronic notification to Bob Batson, Executive Director of the Tennessee Funeral Directors Association, as well as Dawn Ellett with TFDA on August 1, 2018. I emailed a copy of the notice of rulemaking hearing form along with electronic notification to Malcolm Butler, liaison to the board from the Tennessee State Funeral Director and Morticians Association on August 1, 2018. I emailed a copy of the notice of rulemaking hearing form along with electronic notification to Cindy Faree, Executive Director of the Cemetery Association of Tennessee on August 1, 2018. Additionally, on August 1, 2018, notice of the rulemaking hearing was placed on the website for the Department of Commerce and Insurance in 2 locations under the general calendar as well as on the funeral board page under public meeting information. A link to the copy of the notice of rulemaking hearing form containing the text of the rules was provided on both of these pages.
Thank you. Is there anyone else present that would like a red line copy of the rules before we begin? For the record, I will note there are none. At this time, I will read the substance of the proposed rules into the record, followed by the Regulatory Flexibility Addendum, otherwise known as the Economic Impact Statement and the Impact on Local Government Statement. Following such, there will be time for the public to comment. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. Following rules were adopted by the board, and the board approved the setting of a rulemaking hearing at its regularly scheduled board meeting on March 13, 2018. These changes are as follows. Amendments. Rule 0660-01-.03 changes is amended to add the permanent closure of a funeral establishment to the list of information that must be reported to the board in writing within 10 days of the effective date of the change. Rule 0660-02-.01 examination procedures is amended to clarify changes in the testing procedures. For example, the board no longer administers any of the exams. Instead, a testing agency administers all exams. These amendments clarify such and further clarify that an applicant must pass either the SBE or NBE and the LRR prior to the issuance of a license, with a 30-day waiting period between unsuccessful attempts for each examination. Finally, this amendment states, quote, examination results for the laws, rules, and regulations examination, LRR, shall only be valid for 1 year. The requirements for licensure cannot be satisfied unless the completed application and all required supporting documents for licensure are filed with the board within 1 year following the date of successful completion of the LRR, end quote. Rule 0660-02-.02 grading procedures. It's amended to specify that the grades are sent from the testing agency directly to the executive director of the board in a format prescribed by the board. The requirement that the executive director present the examination results to the board is deleted. Furthermore, the passing grade is amended from 75% to 75.0, and it is clarified that this is the passing grade for the LRR as well. Finally, a provision that permitted regrading of any exam upon the examinee's request is deleted and replaced with a provision that states, quote, any examinee who disputes the results of any examination shall be wholly responsible for resolving the dispute directly with the testing agency and any additional costs incurred as a result of the dispute, end quote. Rule 0660-03-.01, Student and Apprentice Registration. It's amended to reduce the fees for students from $70 to $50 and further explains that any dually enrolled student would only have to pay one fee. Apprentice funeral director fees are reduced from $70 to $50, and apprentice embalmer fees are reduced from $70 to $50. Rule 0660-04-.01 registration is amended by adding, quote, a person beginning a required course of study, quote, to the registration requirements. The following additional provisions are added as paragraphs 2 and 3 of that rule. Paragraph 2 states, a person shall not re-register for an apprenticeship if the person previously completed an apprenticeship or less than 12 months have passed since substantial completion, over 51%, of an apprenticeship. Upon a showing of good cause, the waiting period of 12 months may be waived by the board. Paragraph 3 states, an application for apprenticeship registration shall be fully completed by a registrant within 90 days of the receipt of the application in the board's office. After 90 days have passed, any incomplete registration application shall be closed. Rule 0660-05-.01 application is amended by adding the following as newly designated paragraph 3. And it states, an application for licensure as a funeral director or embalmer shall be fully completed by the applicant within 90 days of the board's receipt of the application. After 90 days have passed, any incomplete licensure application shall be closed. Rule 0660-06-.01 application is amended by adding the following as newly designated paragraph 2. An application for a funeral establishment shall be fully completed by applicant within 90 days. After 90 days have passed, any incomplete licensure application shall be closed. Rule 0660-06-.02 fixed place of business is amended by giving the board more discretion to look at the type of professional signage in general. In addition, it adds 2 additional factors for determining whether a proposed fixed place of business or establishment is devoted to the care and preparation of human bodies. These factors include the volume of preparation services or commemorative services provided for non-human remains, and the type and or volume of advertising materials that offer preparation services or commemorative services for non-human remains. Rule 0660-06-.04, inspection required, is amended by adding the following provision. The board shall require a reinspection of an establishment prior to the establishment offering services involving the preparation of non-human remains. And that's paragraph 2. Rule 0660-09-.01, requirements for a crematory, is amended by deleting the following provisions. By deleting the following provision. At no time shall any crematory be used for any purpose other than the cremation of dead human remains. And the following paragraphs are added. Paragraph 10 states, at no time shall any cremation chamber, retort, refrigerator, urn, container, tool, or implement be used to prepare or store both dead human bodies and dead non-human bodies. Each cremation chamber, refrigerator, urn, container, tool, or implement shall be utilized exclusively for either dead human bodies or dead non-human bodies. Paragraph 11 states, at no time shall any cremation chamber or retort designed or manufactured for cremation of dead human bodies be utilized for any other purpose. Finally, paragraph 12 states, all cremation chambers, retorts, refrigerators, and containers shall be labeled to designate usage for the preparation or storage of either dead human bodies or dead non-human bodies if the establishment offers such services for dead non-human bodies. Rule 0660-10-.03, continuing education requirements, is amended by adding the following provision, which is applicable to renewals as well as reapplications as for initial licensure. And it states, of the 10 hours of continuing education coursework, 5 hours must be attended in person, which means it shall be completed in the physical presence of the provider of the coursework or through an interactive virtual program that requires participants to confirm their presence during the program. In addition, the following provisions are added to this section. A licensee may receive 1 hour of continuing education credit per renewal period for an in-person attendance of a regularly scheduled board meeting. A licensee may not repeat the same continuing education course within consecutive renewal periods. Rule 0660-10-.04, qualifying continuing education programs, is amended by adding the following as a new appropriately designated paragraph, and it's designated as 9. It states, a program shall be deemed an interactive virtual program that requires participants to confirm their attendance during the program if it meets at least one of the following qualifications. A real-time stream presentation that permits the submission of questions, facilitates group chat, or solicits responses from licensees through surveys, multiple choice questions, or similar means. B, requires a unique login and disables the ability to skip through content. Or C, monitors licensees' participation and includes a testing component that requires a passing grade in order to complete the program. Rule 0660-10-.05, duties of program sponsors, is amended by a new requirement that requires them to keep a record pertaining to their continuing education program. The record should consist of a statement indicating whether the program qualifies as an interactive virtual program that requires participants to confirm their attendance during the program, and if so, the specific qualifications met as identified within Rule 0660-10-.04, paragraph 9. Rule 0660-11-.02, preparation rooms, is amended by deleting the text of paragraph 6 and substituting instead the following language so that as amended, paragraphs 6 through 8 shall read, and I'll read the deleted portion first. The deleted portion states, the preparation shall be used for no purpose other than the preparation of dead human bodies. The revised paragraphs read, starting with paragraph 6, each preparation room shall be dedicated exclusively to the preparation of either dead human bodies or dead non-human bodies, and signage shall be posted on or immediately adjacent to the entry door of the respective preparation room indicating the designated purpose. Paragraph 7 states, at no time shall any refrigerator, container, tool, or implement be used to prepare, hold, or store both dead human bodies and dead non-human bodies. Each refrigerator, container, tool, or implement shall be utilized exclusively for either dead human bodies or dead non-human bodies. Paragraph 8 states, all refrigerators and containers shall be labeled to designate usage for the preparation of storage of either dead human bodies or dead non-human bodies if the establishment offers services for dead non-human bodies. Rule 0660-11-.05, professional conduct, is amended by deleting the text of the rule in its entirety and substituting instead the following. All persons engaged in the profession of funeral directing, embalming, or operation of a funeral establishment shall at all times act in a professional manner, including but not limited to the following. Members of the public shall be treated in a reasonable manner. Unreasonable treatment is conduct that falls below the standard of professional conduct, including but not limited to abusive, aggressive, hostile, or disrespectful conduct, or being unresponsive to a member of the public for an unreasonable period of time without justification, such as not returning phone calls, not answering inquiries, or leaving a member of the public unattended. We'll skip down to paragraph C, where the changes resume. Paragraph C states, if a particular funeral establishment has custody of a decedent's remains, but is not selected by a person with a vested right under TCA 62-5-703 to control the disposition of the remains, the funeral establishment must release the remains to the establishment that is properly selected, regardless of whether the cost of any merchandise or service provided by the initial funeral establishment are paid at the time of release. Such costs shall remain payable by the selected funeral establishment. Failure to pay upon lawful demand may result in disciplinary action imposed by the board. Nothing herein shall be construed to affect the civil liability of the responsible party or other persons under relevant law. There are also amendments to paragraph E. Paragraph E essentially expands unprofessional conduct to include failure to respond to any notice from the board, not just the notice sent when a complaint is initially opened. Paragraph F is amended, and it adds funeral director or embalmer to the rule regarding not unreasonably delaying the filing of a certificate of death. We'll skip to paragraph H. Paragraph H states, the license of any licensee whom the board finds has engaged in sexual misconduct with a dead human body may be revoked by the board. If the board determines disciplinary action that does not include revocation is appropriate in any case involving sexual misconduct, the board shall issue a finding of no good cause for revocation and thoroughly explain the mitigating circumstances in any order, whether by consent or otherwise. Next, we'll skip to paragraph J, which states a licensee or registrant shall not engage in any conduct that may mislead or deceive the public as to the physical location of any funeral establishment. Finally, paragraph K states, funeral directors, embalmers, and establishments shall conduct themselves in a way that does not offend the reasonable sensibilities of the public and reflects respect for dead human bodies. Moving to Rule 0660-11-.07 records, it's amended by adding the following language as newly designated paragraphs 3 through 5. Paragraph 3 states, each establishment shall provide written notification to the board on a form designated by the board no less than 30 days prior to the preparation of non-human remains at the establishment. An establishment shall obtain a reinspection prior to offering such services to ensure compliance with applicable laws, rules, and regulations. Each establishment shall promptly provide written notification to the board if it ceases to offer such services. Paragraph 4 states, each establishment shall ensure that its price list and any other documents required by the FTC rule or TCA Title 62, Chapter 5, and the accompanying rules and regulations do not include any services or merchandise for non-human remains. Paragraph 5 states each establishment shall ensure that any trust accounts required by the FTC Funeral Rule or TCA Title 62, Chapter 5, and the accompanying rules and regulations do not include any funds derived from services or merchandise provided for non-human remains. Next, moving to Rule 0660-12-.01, removal service, is amended by adding paragraph 4, which shall read, at no time shall a dead human body be transported in any manner with a dead non-human body unless prior written consent is obtained from the responsible party for the dead human body. And that would conclude the amendments. There is a new rule. Chapter 0660-03 fees is amended to Rule 0660-03-.12. Document review on the table of contents, and it reads, the submission fee for any cremation authorization form not furnished by the board shall be $100. Such form submitted for review shall include two versions, a final version of the document and a version which shall include footnotes or endnotes that identify those provisions that are required by law and cite the applicable statute and or rule. An additional $100 fee shall be assessed for each resubmission of the form due to nonconformance with the applicable laws and rules. And that would conclude my reading of the changes, including the amendments and the new rules for this set of rules. Next, I'll be moving to the regulatory flexibility addendum. Pursuant to Tennessee Code Annotated 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rules affects small business. Number one, the type of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. Response. These rules affect funeral establishments, most of which are defined as small businesses under Tennessee Code Annotated 4-5-102, paragraph 13. There are approximately 584 licensed funeral establishments in the state of Tennessee. Many funeral establishments pay the fees for their employees. Therefore, small businesses would benefit from the fee reductions for apprentice funeral directors, apprentice embalmers, student registrations, and the initial licensing fees of both funeral directors and embalmers. Number two, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. Response. These rules require a submission fee for crematories to have any cremation authorization form not furnished by the board reviewed and approved. These rules further require that such forms include a version that identifies and cites those provisions within the form that relate to an applicable law and or rule. The submission fee is $100. If the form is determined to not be in compliance with the law, the resubmission fee is $100. No additional professional skills are necessary for the preparation of the report or record, as such forms were already being submitted by crematories. Number three, a statement of the probable effect on impacted small businesses and consumers. Response. These rules will have a positive effect on impacted small businesses and consumers. These rules provide clarification on a number of substantive issues such as the examination process, continuing education requirements, and provision of services involving non-human remains. These rules incentivize licensees to become more involved in the regulatory process. These rules also reduce the fees for students, apprentices, funeral directors, and embalmers. These rules will result in a potential increase in the number of individuals employable as funeral directors and embalmers. Number four, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business. Response. There are no less burdensome, less intrusive, or less costly methods of achieving the purpose of these proposed rules. Number five, a comparison of the proposed rule with any federal or state counterparts One second, please. Okay, I had to double check something. A comparison of this rule with any federal or state counterparts. These rules are required pursuant to 2016 Public Chapter Number 911 as well as 2017 Public Chapter Numbers 144, 154, and 158, and they are comparable to other states. There are no known federal counterparts to these rules. And finally, number six, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Response. Exemption of small businesses from all or any of the requirements of the proposed rule would be unfeasible, as the majority of funeral establishments are defined as small businesses under Tennessee Code Annotated 4-5-102, paragraph 13. Next, I will move to the impact on local government statement. Pursuant to Tennessee Code Annotated 4-5-220 and 4-5-228, Any rule proposed to be promulgated shall state in a simple declarative sentence without additional comments on the merits of the policy of the rules or regulation, whether the rule or regulation may have a projected impact on local governments. In our response, these rules will not have an impact on local government. Next, we'll move to the comment portion of this hearing. Mr. Gribble, were any written comments received by the board office regarding these rules?
I have not received any written comments regarding the rules.
This time, I will be retrieving the sign-up sheet and starting from the beginning of that sheet to the end to take comments from those present at the meeting today. Mr. Phillips, are you still here and seeking to comment on these rules?
I do not wish to comment.
Thank you. For the record, Mr. Phillips does not wish to comment on the rules today. Mr. Span, do you wish to comment on the proposed rules today?
Very briefly, I'm Steve Span with John Gupton College here in town, and I just wanted to come forth to make a couple of comments and compliments on the changes that you're making to the rules. I've been attending these meetings for the past 24 years or so, and I see monthly the problems and the situations that you folks put yourself in front of on a monthly basis, and I appreciate the things that you do for the state and for our industry. As you look at the fee structure, and most of this affects my students that are attending school, I appreciate you folks recognizing the need to reduce the student apprenticeship, the student application fee and the apprenticeship application fee. As you know, most students, when they're going, it takes a while after you get out before you make very much money. So reducing those things. About a third of my students that attend Gupton's are from other states, and so I still require them to sign that, to register that as student apprenticeship, because they're going to be working in the prep room in Tennessee. So that also helps for those folks, and they'll probably never try to get a license in Tennessee. So that's very beneficial. And the second thing that was one of the first things on your list was the changing the national board process, where you are adding in there that you can any exam that's approved by the just a little closer. All right, that might be very advantageous to the board to give them an opportunity if there were to have other things that come up that would allow the board to approve another exam other than just the national board exam. My comments. Thank you.
Okay, at this time, I will note for the record that Mr. Span did not propose any changes, but I'll give the board an opportunity to respond directly to those comments on the record.
The board certainly appreciates Mr. Span's comments and will take them into consideration.
Thank you. Are there any other comments from those present at today's meeting? Seeing that there are none, this concludes the rulemaking hearing. The comment period has concluded, as there's no necessity to hold the comment period open for any length of time based on the sufficient notice and the opportunity to comment today. At this time, we will need to have a motion and roll call vote for the board to adopt the rules that were discussed today. This is a requirement per Tennessee Code Annotated 4-5-222. So we would need to have the board adopt the hearing rule language, and we'll move forward following that vote.
All right, do we have a motion to approve?
So moved.
Second.
I have a motion by Mr. Cochran, a second by Mr. McKinney. All in favor?
Aye.
And do we need to call the roll? Ms. Bohannon, if you would call the roll.
Dennis Bridges,
Yes.
Mark Cothran,
Yes.
Robert Davis,
Yes.
Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, all members adopted the hearing rules.
Okay, next, we will need the board to adopt the regulatory flexibility addendum / economic impact statement that was read in the record, and that is before you today. And that will also need to be adopted by a motion and roll call vote.
All right, do we have a motion to adopt the economic impact statement?
Motion to accept.
Second.
I have a motion by Mr. Duffer, a second by Mr. Davis. Ms. Bohannon, would you call the roll?
Dennis Bridges,
Yes.
Mark Cothran,
Yes.
Robert Davis,
Yes.
Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, all board members have adopted the economic impact statement.
Thank you. Next, I'll need a motion and roll call vote to adopt the impact on local government statement required pursuant to 4-5-228, and that was also read into the record, and you have a copy before you today.
And do we have a motion for the local government impact?
Motion to accept.
Second.
I have a motion by Mr. Bridges, a second by Mr. Shackelford. Ms. Bohannon, would you call the roll?
Dennis Bridges, Mark Cothran,
Yes.
Robert Davis,
Yes.
Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, the impact on local government statement has been adopted.
Thank you. We're going to move to information that's required by the Joint Government Ops Committee, and I will go into that in more detail. And following the review of that information, we'll also need another motion and roll call vote as it relates to that information. All agencies, upon filing a rule, must submit the following pursuant to TCA 4-5-226 I-1. A brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. Response. These rules clarify the examination and grading procedures, adjust the fees for a number of licensees, create a submission fee for specialty forms to be reviewed, establish parameters on registering for apprenticeships, establish 90-day time limits for completion of various applications for registration and or licensure, specify indicators regarding fixed places of businesses devoted to the care and preparation of dead human bodies, specify new requirements related to the care and preparation of non-human remains, clarify the new in-person and or virtual continuing education requirement, and add the option of attaining continuing education credit by attending a regularly scheduled board meeting. These rules are expected to result in the following changes. The board and existing establishments will be able to receive prompt notification of the permanent closure of other establishments. Prospective licensees will have more clarity regarding the examination process. Students, apprentices, funeral directors, and embalmers will pay lower fees for their respective registrations and licenses. Establishments will have better forms to provide consumers as a result of the requirements to more closely review these documents. More individuals will be eligible to work as funeral directors and embalmers due to additional restrictions related to perpetual apprenticeships as well as incomplete applications. More businesses will be able to diversify into the business of non-human remains due to additional clarity provided by these rules regarding the requirements for such. More businesses will be able to enter the continuing education market due to the additional clarity provided by these rules as it relates to in-person attendance for 5 of the 10 required hours. More licensees will become involved in the regulatory process because these rules authorize continuing education credit for attendance of a regularly scheduled board meeting. And finally, the conduct of licensees shall improve as it relates to the reasonable treatment of the public. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines thereto. The first is 2017 Public Chapter 144, that's TCA 625-313. In relevant part, this law broadens the scope of services that may be performed by funeral establishments by expanding from the current restriction of preparation for disposition of dead human bodies only to the remains of any previous living thing. This bill also allows a funeral establishment to perform commemorative services, which is defined as any ceremony for the dead prior to final disposition. The commemorative service also expands the current restriction of the usage of funeral establishments from the current restriction of dead human bodies to that of any previously living thing. Next, 2017 Public Chapter 154, and that's TCA 62-5-601C. This bill requires that the 10 hours of continuing education coursework include 5 hours that are attended in person or via virtual format that requires a periodic attendance confirmation. 2017 Public Chapter 158, and that's TCA 62-5-709. In relevant part, this law provides that if a second funeral establishment received the remains from a funeral establishment that has provided merchandise or services, that both the second funeral establishment and the responsible party are responsible for any costs incurred by the initial establishment. Though payable, there is no requirement that the initial funeral home be paid prior to the release of the remains to the receiving funeral home. C. Identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. Response. Many funeral establishments in the state of Tennessee are members of either the Tennessee Funeral Directors Association or the Tennessee State Funeral Directors and Morticians Association. These entities would be most affected by this rule. Board staff held in-person meetings with both of these groups regarding these rules prior to adoption. Many of their comments and suggestions were taken into consideration in the drafting of these rules. These two organizations will likely either defer to any determination of the board to adopt these rules or urge adoption of these rules. D. Identification of any opinions of the Attorney General and Reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. Response. There are no known Attorney General and Reporter opinions or judicial rulings that directly relate to these rules or the necessity to promulgate these rules. E. Identification of any opinions of the E. An estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasonings upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's budget or $500,000, whichever is less. These rules are expected to have an overall minimal and fiscal impact. The program's annual budget is $555,800. So materiality would be established at 2% of this budget in the amount of $11,116. Based on the average number of initial applications from fiscal years 2016 and 2017, the estimated reduction in annual revenue is $4,080 for the fee reductions applicable to apprentice funeral directors, apprentice embalmers, student registrations, and the initial licensing fees of both funeral directors and embalmers. The fiscal impact of the fee for submission of cremation forms for review and approval would not be material. There are currently only 68 licensed crematoriums, which means the greatest amount of additional revenue that could result from this fee for additional submissions is $6,800. It is expected that almost all licensees will continue using the pre-approved form on the website, which will remain at no cost to the establishment. F is identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. And I've identified myself and Mr. Gribble for that. G is identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. And I've identified myself and Mr. Gribble for that as well. And finally, the office address, telephone number, and email address of the agency representatives who will explain the rule at a scheduled meeting of the committees, and that is also Mr. Gribble and myself. Any additional information relevant to the rule proposed for continuation that the committee requests, and the response is none known. So that would conclude the additional information required by the Joint Government Operations Committee, and at this time I would need the board to adopt this information, this statement, with a motion and roll call vote.
Do I have a motion to adopt the additional information required by Joint Government Operations Committee?
So move. Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer. Ms. Bohannon, would you call the roll?
Dennis Bridges.
Yes.
Mark Carthron.
Yes.
Robert Davis,
Yes.
Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, the minutes adopted for the joint government ops.
Thank you. As previously noted, the comment period for these rules has been closed. These rules following this hearing will be put on the rulemaking filing form SS-7039 and submitted to the Attorney General's office for review and approval. Once the Attorney General's signature is obtained, these are filed with the Secretary of State's office and generally become effective 90 days from the date of filing. This would conclude the entirety of the rulemaking portion of this meeting. Thank you.
Mrs. Hooper, on behalf of the board, I just want to say thank you for all the many hours and hard work that you and your staff have put into this, and we certainly do appreciate it very much.
Thank you, Chairman.
Before we move into the legal report, Mr. Shackelford has asked to be called upon.
President, I request that the record of these proceedings reflect that I am recusing myself from all discussions and any votes pertaining to the October 9th, 2018 legal report.
Let the record reflect that Mr. Shackelford has recused himself from the legal report. At this time, I'll call on Ms. Gino.
Good morning. As you know, my name is Ashley Gino. I'm an Assistant General Counsel for the Regulatory Boards Division, and I will be presenting the October legal report this morning. The first two items on the legal report are related. Complaint number 2018-04-9121 against an establishment, and complaint number 2018-04-9151 against a funeral director. The establishment has some disciplinary history, while the funeral director does not. On May 2nd, 2018, a board field representative performed a routine inspection of the respondent establishment. At that time, the respondent discovered respondent funeral director continued to serve as the manager of respondent establishment for 2 weeks while his license was expired. He also served in the capacity of funeral director with respect to one deceased person. In response, respondent funeral director did not deny the allegations and indicated he is currently working on steps to ensure that renewal dates do not go unnoticed in the future. Recommendation: respondent establishment, authorization for a formal hearing, authorization of a civil penalty in an amount of $250. Respondent funeral director, letter of warning.
I move to accept council's recommendation.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran to accept the recommendation. All in favor?
Aye.
The third item on the report is a complaint number 2018-044851 against an establishment with no disciplinary history. On June 27, 2018, a board field representative performed a routine inspection of the respondent establishment. At that time, the representative discovered: 1. The immediate burial price range was incorrect when compared to the price of caskets offered for sale on the casket price list. 2. The immediate burial price with an Apollo 20G steel non-gasketed casket was incorrect when compared to the price of the Apollo 20 gauge steel casket on the casket price list. 3. Direct cremation on the general price list did not include the required Federal Trade Commission disclosure. 4. The casket price range listed on the general price list was incorrect when compared to the price of caskets on the casket price list. 5. The outer burial container price range listed on the general price list was incorrect when compared to the price of the outer burial containers on the outer burial container price list. 6. Respondent's website advertises direct cremation $1,195 / funeral package with 20G casket starting at $4,200. In response, respondent indicated all the items listed in the citation were corrected, all pricing was removed from the website, and the general price list was corrected. In support, respondent supplied an updated general price list dated June 28, 2018. Recommendation: letter of warning.
Questions? There a motion?
Motion to accept.
Second.
I have a motion by Mr. Bridges, a second by Mr. Duffer to accept the recommendation. All in favor?
Aye.
The next item on the legal report, number 4, is complaint number 2018-041131 against an establishment with no disciplinary history. On or about June 22, 2018, a complaint was filed against respondent alleging respondent published a non-compliant advertisement in a newspaper. The advertisement contained in part the following text. Quote, standard funeral, all professional services, viewing, quality casket, no out-of-pocket expense when using your life insurance. Less than $3,998. Close quote. In response to the complaint, respondent argued because the advertisement contained the qualifier less than, it was not in violation of Tennessee Code Annotated 625106. Tennessee Code Annotated 625106 provides any advertisement by a funeral director or embalmer for the sale of merchandise or services that indicates a specific price shall include an itemized listing of each and every item, procedure, or service, and shall show the price of the item. Failure to include the itemized price listing in any advertisement constitutes misrepresentation or fraud in the conduct of the business of the funeral establishment or false and misleading advertising as used in 625317. Recommendation, letter of warning.
Motion to accept.
Did they agree to take down their ads?
No, because they argued that their advertisement isn't in violation of that statute.
With that being said, why is it just a letter of warning?
A letter of warning was recommended given the lack of a disciplinary history on the part of the establishment.
So is this going to continue? Is this advertising going to continue? If it's in violation, he needs to agree to, or he or she needs to agree to change his advertising. Because if we just send a letter of warning, more or less that's slapping him on the wrist, and then he continues on doing what he's doing, well, he's still in violation. So should we add a cease and desist on the ad?
I think the board certainly has an option to provide a letter to the respondent and indicate a particular deadline to provide some type of written notification back to the board that the ad will no longer be ran prior to this complaint being closed, if the board so wishes to proceed that way.
First order of business we have is we have a motion on the floor to accept the recommendation. Is there a second for that?
Oh, I'll withdraw that to discuss the cease and desist.
All right. Motion has been rescinded. More discussion?
Yes, I have a question. The respondent says that is not in violation, but what is the legal department's response to that?
I think that the We've looked at the law, and we think that it is really adhering to a very, very technical reading of the rule to say that this isn't a violation. So because it's a letter of warning, that would be the opportunity for the respondent to correct the ad. And if not, we would, assuming that the board took the position that there needed to be the removal of this ad and confirmation of such, we would bring that back to the board if that didn't occur, to review and determine what would be the appropriate course of action.
The rule clearly states that it has to have itemized pricing, correct?
That's correct. And this person, this particular establishment, put the words less than in front of a specific price. And so, you know, the recommendation letter of warning is because that does appear to be in violation of the intent of that particular provision of the law.
I'm okay with a letter of warning provided that they agree to change their advertising.
Do you have a timetable for that? If you just leave it open.
Just 30 days too long? I mean,
Other thoughts from board members?
I agree with the 30 days.
that's pretty reasonable, give them 30 days to, you know, correct the ad, and a letter of warning.
So just to clarify, what it would be is a letter that would include a 30-day timeline by which to provide the board with written notification that the advertisement is no longer running and they've agreed to not run that particular ad. Is that correct?
Yes.
Okay, we would need a motion to that effect and a vote.
So move.
Making that in form of a motion, Mr.
Yes.
McKinney? Okay.
Yes, sir.
Have a motion by Mr. McKinney,
Second.
second by Mr. Bridges. All in favor?
Aye.
Opposed? All right. Mr.
Thank you. The next several items on the report are associated with the same summary. Item number 5, complaint number 2018-04-5651 against establishment number 1. Item number 6, complaint number 2018-04-7841 against establishment number 2. Item number 7, complaint number 2018-04-5771 against funeral director. Item number 8, complaint number 2018-04-7871 against funeral director. Item number 9, complaint number 2018-04-5621 against embalmer. And item number 10, complaint number 2018-04-7901 against embalmer. Neither establishment have disciplinary history. The funeral director and embalmer also do not have a disciplinary history. On April 3rd, 2018, a board field representative performed a routine inspection of the respondent establishment number 1 and respondent establishment number 2. At that time, the representative discovered respondent funeral director / embalmer had let his licenses lapse. Specifically, his licenses expired on October 31st, 2017. However, at the time of the inspection, he had yet to renew his licenses. During this period of expiration, respondent funeral director / embalmer served in the capacity of funeral director and/or embalmer with respect to 17 deceased persons. In response, respondents indicated they were unaware respondent funeral director / embalmer had let his licenses lapse. They further indicated respondent funeral director / embalmer was instructed on April 3, 2018, the date of the inspection, to stop serving as a funeral director and/or embalmer until his licenses were reinstated. The licenses were reinstated on July 31, 2018. Recommendation: Respondent establishment number 1, letter of warning. Respondent establishment number 2, letter of warning. Respondent funeral director / embalmer, authorization for a formal hearing, authorization of a civil penalty in an amount of $250.
Move to accept council's recommendation.
Second.
Motion by Mr. McKinney, second by Mr. Duffer to accept the recommendation. All in favor?
Aye.
Opposed? Ms. Gino?
I have 3 items listed as represents this morning. The first 2, item number 11 and item number 12, are related. Item number 11 is complaint number 2017-028871, and item number 12 is complaint number 2017-028891. These complaints were originally presented as follows. This complaint alleges unprofessional conduct of a funeral director and embalmer. The alleged allegation stems from an arrest regarding domestic violence. The respondent failed to respond. However, since the time of the arrest, the respondent has entered into a plea to misdemeanor domestic assault as an Alford plea, which allows the respondent to maintain his innocence and be placed on probation for less than 1 year in order to attend anger management classes. The original recommendation was for authorization of a formal hearing, authorized settlement by consent order with a $500 civil penalty against each license for failure to respond, and conduct not becoming of a funeral director and embalmer. The update on this one is there is no additional evidence that has become available and no witnesses have come forth, which would be necessary to proceed to a formal hearing. Therefore, there is insufficient evidence to demonstrate respondent committed domestic assault and therefore acted unprofessionally. By entering into an Alford plea, respondent asserted innocence and did not admit to the criminal act. So the updated recommendation is to close.
Know who filed the original complaint?
I believe it was administratively opened.
Thank you.
Further discussion?
And was there never at any time any response from the licensee?
There was never a written response from the licensee, but I have spoken with the licensee regarding the complaints.
Okay, so you have spoken with the person on the phone then, or
yes,
email?
I have spoken with the licensee by the phone.
Okay, thank you.
Mm-hmm.
there a motion?
Everybody's still thinking.
I would like to clarify that the $500 penalty was paid.
No, we could not reach a settlement with the licensee.
Recommendation of legal counsel to impose a $500 civil penalty that they didn't pay.
Yes, so the board did accept that original recommendation, which was authorize formal hearing and authorization of a settlement by consent order with a $500 civil penalty against each license. So I believe it was a $1,000 civil penalty combined because it's a funeral director license and embalmer license. But we were unable to reach settlement with the licensee.
And the reason for that?
The reason for being unable to reach settlement?
Yes. He just refused to pay?
I'm assuming the licensee is maintaining their innocence.
Yes, yeah.
Okay, but it would have been good if they would have at least written the board a letter, explaining his situation.
I will say again, we are providing an update on this one because like I have in the report, no additional evidence has become available and no witnesses have come forth, which we would need to proceed with a formal hearing on the conduct not becoming of a funeral director and embalmer charge.
Sorry.
Again, by entering into the Alfred plea, he asserted innocence and did not admit to the criminal act.
Basically, regardless if he paid or not, we have nothing to base a civil penalty on, is ultimately the case.
As for the unprofessional conduct, yes. As for his failure to respond, we do have a rule that licensees are required to respond, and you could assess a penalty based on the failure to respond.
That's what's disturbing to me is the licensee didn't take this serious enough to at least respond in writing back to the board as to the allegations, and in order to, assert his innocence and say, yes, I'm going to anger management classes and so forth. I just think if any licensing authority has a complaint against you or contacts you, that you should respond.
Thank you, Mr. McKinney. At this time, we're checking to see exactly what the letter said that went to the licensee that accompanied the complaint, and to see whether it did, in fact, indicated that the response had to be in writing. So if it's possible, if we could go ahead and move to the next complaint while our paralegal checks on that, we could keep things moving.
Sure.
The next item on the legal report is item number 13. This is complaint number 2015-013401 against a funeral director This matter was previously presented to the board at the October 13th, 2015 meeting as follows. Funeral home reports that one of their now former funeral directors has been taking checks and depositing them in his own personal account. They show proof that he opened his own account as X, his last name, funeral home, and added a DBA of respondent's name. Upon confrontation, respondent admitted to this practice and told the funeral home that he could not guess how many checks he had done with this. Respondent states that this is a civil dispute. Complainant has found 60 checks for a total of $122,613.18 from November 2013 through the present. Respondent was arrested on September 15th for theft. The respondent states that this was a civil dispute. The original recommendation was revocation of funeral director's license and authorization for hearing. The board accepted that recommendation. The update we have is that respondent submitted a signed and notarized letter surrendering his license as part of a resolution of a criminal case prosecution. He indicated in the letter that he will heretofore refrain from further registration as a funeral director licensee, embalmer, or burial services provider in the state of Tennessee, and that he will not make any further application for such license, nor shall he accept any further license granted in the state of Tennessee for these services. The updated recommendation is the individual has voluntarily surrendered the funeral director license, so we would recommend closure.
Sorry.
Motion to accept.
Second.
I have a motion by Mr. Cochran, a second by Mr. Duffer to accept the recommendation. All in favor?
Aye.
We have checked on items 11 and 12. The letter that was sent to the licensee did provide the following language. A written response must be filed with this office within 14 days of your receipt of this notice. In your response, please provide a detailed explanation for the allegations presented. There was also language in the correspondence sent to the licensee that stated you may submit your response online by visiting www. Okay. If you need me to read the entire URL, I will. The online form is submitted instantly and will allow you to attach any applicable documentation or supporting correspondence relevant to the complaint allegations.
And it also provided an email address where a written response could be submitted. Looking at the rules, you all do have a rule of professional conduct related to this issue. It's Rule 0660-11-.05, 1D, and it states, any licensee, upon receiving notice that a complaint has been opened against the licensee, shall respond within the time specified in the notice, provided the director may grant a request for extension submitted within the period of time stated in the original notice. As far as we're aware, there was no request for an extension. Mr. Can you confirm that?
That is correct. We did not receive any request for an extension on the response.
So while the board is concerned about the recommendation to close, it is an option for the board to consider this rule of professional conduct as a grounds for proceeding with the case on that basis alone, and to determine an appropriate disciplinary action for that failure to respond.
I'll make a motion that he be assessed a civil penalty of $500 for not responding to the board and authorization for a hearing.
Is there a second?
Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye.
Opposed?
One moment, please. We're reviewing something in this file.
Too late.
So for the record, the board assessed a $500 civil penalty for failure to respond in this matter. And does the board agree to accept the recommendation of closing the matter as to the specific allegations of domestic assault?
Yes.
And just to clarify, is that $250 per license?
Yes, that was my intent.
Okay.
Apologize for not making that clear.
I thought of that too. I made the second motion, and I'll continue to keep that on the record.
I think we will need a motion to close as to the domestic assault allegations
Yes. Okay,
and proceed. You already voted to proceed with the unprofessional conduct violations.
I move to close.
Second.
On the other matter.
Motion by Mr. McKinney, a second by Mr. Duffer to close and accept the recommendation. All in favor?
Aye.
Opposed?
Thank you. With that, that would conclude the legal report.
Thank you, Ms. Gino. Next item is our director's report. Mr. Gribble.
Thank you, Mr. President. Board members, the first item is the legislative update. We have not been notified by either the Tennessee State Funeral Director and Morticians Association or the Tennessee Funeral Directors Association of any new legislation that they intend to pursue during the next legislative session. Licensee report. This is a report of licenses administratively approved by the Executive Director pursuant to the Board's authority for the period of August 14, 2018 through October 8, 2018. And you see a number of establishments listed there as well as individuals on that report. Closed establishment report. One establishment has reported closing since the last board meeting. That's Tribute Funeral and Cremation Services, which was located at 240 Suncrest Street in Johnson City, Tennessee. Disciplinary action report. This is a report of consent orders that have been administratively accepted or approved by the Executive Director pursuant to Board authority and as reported on the July and August 2018 Regulatory Board's disciplinary action reports. And you have three cases listed there and pertaining to that. The complaint report. As of yesterday, October 8, 2018, there were 28 complaints open related to either a funeral director or an embalmer and 30 complaints regarding the establishment for a total number of open complaints of 58. Be glad to answer any questions, and if you don't have any, that would conclude my report, Mr. President.
Move that we accept the director's report.
Second.
Motion by Mr. Kinney, second by Mr. Duffer to accept the report. All in favor?
Aye.
President, legal and staff would ask for about 12 minutes recess, maybe to 11:30. Is that permissible by the board?
That's fine. We'll recess till 11:30. It's 11:30, and I'll call the meeting back to order. And I'll turn to Mr. Gribble.
Or is the board to consider licenses? The first ones are individuals. The first one is Brandon Maurice Berry from Memphis, Tennessee, who has an application for a funeral director and embalmer. Based on the applications, the board, among other pertinent statutes and rules, may examine TCA 62-5-317, making determinations whether the applicant meets the requirements for this licensure. Mr. Berry, if you will, please come up and have a seat. And if I know Mr. Naylor's with you, please speak into the microphone there. There's one to share, and you may have to speak a little bit loud in order for the mic to pick up your conversation. If you would, Mr. Berry, go ahead and introduce yourself to the board and present to them whatever presentation you'd like to make to them, and Mr. Naylor likewise as well.
Good morning, board. I sincerely thank you all for having me here, just to consider me for my license. Just been communicating with Mr. Gribble the last 2 years while in school, just to have a determination as to whether funeral services is just the most ideal profession for me. Working with Mr. Naylor over the interim of 2 years, I have known this just to really be my vocation and calling. I think very few people find their vocation and calling, but as working with Mr. Naylor in school, being the top of my class, receiving the Mississippi Student of the Year Award, graduating again with a 3.9 GPA, I've really learned that this is, I guess, my vocation and calling, and just really sincerely want you all to grant me the license to move forward to just work out my calling with the people and in funerary services.
Good morning, board. My name is Wendell Naylor, manager of M.J. Edwards Funeral Home, Memphis, Tennessee. The 2 years that Mr. Berry has been with me has been outstanding. Out of the 36 years I've been licensed, and I know, shocking everybody, I know y'all thought I was 36, but I'm not. And out of all the apprentices I've had over the years, Mr. Berry just stands out. He reminds me so much of myself, to where he works from can to cane, 6 to 7 days a week. He goes whatever I've asked him to do when it comes down to us in the prep room. I will tell him to get this or to get that, and I will explain to him. Then he will go back and he will research on that fluid or that product that we're using, and he'll come back and he may tell me a little something else about it that I did not know that it would do. And over the last 2 years, and with him working with the families that he's had the opportunity to sit in with me on, I've seen him go into his pocket to go out and buy props to make sure that the family has a very memorable memorial service, a funeral service, and that, you know, where he's gone just that extra mile. And those are the things that today in time that the families really do appreciate now. And so coming before you, asking you all to, to grant him his license, I feel he would do the industry a great justice as a licensed funeral director as well as an embalmer.
Does the board have any questions? In the application, it was marked as far as having a conviction or entering a plea of guilty. Certainly that is the reason, one of the reasons that you are before us today.
The information that was provided is contained there in your documents before you.
Mr. Berry, have you worked for a funeral home other than M.J. Edwards?
No, sir. M.J. Edwards is the first funeral home I've worked for.
Okay, thank
Yes,
you.
sir. Thank you.
And you haven't had any problems since
Sir.
this incident in 2013?
No, sir.
Okay. How long had you been employed with the City of Memphis?
A short tenure of about 2 years.
Okay.
Yes, sir.
I'm impressed with Mr. Berry's test scores. Very good.
Are there any other questions or concerns for the applicant?
Mr. Chairman, seeing that all of his documents are in order and everything, I offer a motion to grant license to Mr. Berry, funeral director and embalmer.
Second.
I have a motion by Mr. Davis, a second by Mr. Duffy to grant the application or grant the licensing. All in favor?
Aye.
Opposed? Mr. Berry, congratulations. We wish you well in your career in funeral service, and just keep up the good work.
Thank you. I really appreciate you all.
Absolutely.
Thanks.
Thank you, board.
Thank you for being
Appreciate
here.
you being a good mentor.
Thank you for making the trip.
Next person to appear before the board is Jason David Quisenberry from Nashville, Tennessee, who is applying as a funeral director and embalmer by Reciprocity from Kentucky. And this involves TCA 625317 as well. Mr. Quisenberry, if you will, introduce yourself to the board and make whatever presentation you'd like to as well.
Hello, ladies and gentlemen. My name is Jason Quisenberry. I'm a third-generation funeral director and embalmer. I was born and raised in my grandfather's funeral homes in southern West Virginia. I left southern West Virginia to get away from an unpleasant situation, an unpleasant environment, and unfortunately my father's opioid addiction. Recently my brother has moved to the Nashville area, and he's brought my nieces with him. My sister is planning on moving to the Nashville area, and upon retirement, my mother is also planning on moving to the Nashville area. She lives in Louisville, Kentucky right now. Two of the nieces that my brother has custody of belong to a sister that I lost in April of 2017, and I have no children of my own, and they're the closest things that I have to my own children, and I'm trying to remain as close to them as I can, as I consider myself to be part of a team that's helping raise, trying to produce two productive adults. I have been extremely fortunate to find a position with Spring Hill Funeral Home here in Nashville. And I work for a Mr. Samuel Brewer, who's with us today, and a Mrs. Tara Best. And growing up in the funeral business, especially in southern West Virginia, I watched my grandfather give away many funerals to people who didn't have the means to afford one. And one of the things that I love about the people that I've found a position with is they can handle high-profile cases, but they also handle the folks who don't have anything. And that being said, I am here seeking licensure from the state of Tennessee.
Thank you, Mr. Quisenberry.
Quisenberry, were you a resident of Florida at the time of this incident? Or?
Yes, sir.
Just have to pay some fines. There wasn't any probation period or anything like that.
No probation, sir. No diversion. Okay. I don't know what it means. They withheld adjudication, and I believe they were lenient on me because I had no priors. I'm not speaking out of place, but the board requested certified documents from South Florida, and it was not feasible for me to go to South Florida to get those documents for you. So I hired an attorney to do so, and I've also retained that attorney to help get this off of my record. It'll be about a 6-month process.
It appears that you have 4 letters of recommendation, 2 from Kentucky individuals and 2 from individuals you have known for a relatively short period of time.
Yes, sir. And I had 2 more letters of recommendation, but unfortunately they were not dated, and they were
that would be a consideration that the board would have, that 2 of these are recommendations for only a 2-month period.
President, what happened? Those 2 were submitted first, and upon consultation with legal counsel, we asked Mr. Quisenberry to submit people who had known him a longer period of time. So the latter two that are dated October the 1st and September the 30th were then submitted subsequent to her request for that.
And I perhaps have just missed it, but have you renewed your licenses in Kentucky since the time of this incident that occurred in Florida?
Oh, yes, sir.
This is probably in here as well, but you've had no disciplinary action from the Kentucky board.
The renewal process require you to disclose that information to them at the time of your renewal?
Sir, it was not asked.
Mr. Brewer's here. Does he want to speak on your behalf?
My name is Samuel Brewer. I am the location manager at Spring Hill Funeral Home. We were looking for a staff member to join our team about 3 to 4 months ago, and talked to several different people, and Mr. Quisenberry was one of the highest candidates that I spoke with. He came on and joined our team. He has assisted us with helping out with funeral support, various office duties while he's been at our location. I've never had any problem out of Mr. Quisenberry. His attendance has been great. The interaction with families while he's helping with funeral support, the families really look up to him, and I really appreciate him joining our team and wanting to be a resident of Tennessee. Also, all of our staff at Spring Hill think very highly of Mr. Quisenberry, and I've never seen anything out of him in the 3 to 4 months that I've known him that would not grant that you should not maybe consider granting him a license. But of him from a personal level and also from a professional level of what I've seen of him over the last 4 months. When I was calling his references, I think the only negative comment that I received was that sometimes he has a hot head. And we jokingly laughed and said, well, we all can have that at times, but all of his references out of the 3 that I called were all superior references. So thank you for your time today.
Board members, some have asked about his Kentucky licensure. If you look on page 17 of the PDF there, it is director's license was issued June 24, 2013. His embalmer's license was issued June 22, 2015, and both are set to expire July 31, 2019. Same license number, and that's why it says at this time license number 6548 has no disciplinary actions or any pending, and the reason it only lists one number is it's the same funeral director and same embalmer number as well.
Any other questions for Mr. Quisenberry? Is there a motion of acceptance or denial of this application?
Motion to accept.
Second.
I have a motion to accept the application of Reciprocity from Mr. Shackford and a second by Mr. Duffer. All in favor?
Aye.
Opposed? Congratulations, sir.
Next applicant to appear before the board is Scott Thomas Gullett. Gullett is applying for licensure as an embalmer by Reciprocity, and he has already been issued a funeral director license number 20154 that was issued on July 15, 2018. He met the qualifications, educational qualifications, where we could administratively review and approve his funeral director license. However, he's before you today for you to consider 62-5-311B3 in making the determination for his license regarding Reciprocity. And Mr. Gullett, if you will, introduce yourself to the board and whatever you want to say to them.
Morning, good afternoon. I am Scott Gullett. I am a licensed embalmer, funeral director in the state of Kentucky. Before Kentucky, I was also a licensed embalmer in Florida, which I have not recorded because all you needed in the last 5 years. I am in the Keavy area, London area, Jellicoe area of Tennessee, Kentucky. I'm a trade embalmer for Craig Singleton. So we work for a variety of funeral homes in the area. And my boss has asked me if I can be a license in Tennessee, and I said, yes, I'd be happy to help the company as well, to be licensed in Tennessee, and I believe I would be benefit for the families as well, and the owners of the funeral homes in Tennessee as well. I graduated in 1991. Of course, that's been 27 years ago, and I fell for this business due to my handicap because I'm deaf in my left ear and I wear a hearing aid in my right ear. So I was born this way. So I felt comfortable to be in this business.
Mr. Gullett, looking at your employment with Maple Grove Funeral Home and Cremation Services,
Yes.
it says your employment began on 2012 and ended in June of 2015, and that you were a full-time employee, but you only worked 24 hours a week.
I meant to put 24/7. That's what I meant to put down. I was the owner of the funeral home as well.
Did you have any other employees working for you?
Yes. I have my, well, no, I had my partner and my wife. I didn't have any employees, no.
Did the business close, or did you sell, or?
We closed it and we sold it. I'm highly skilled and reconstructive in embalming, and that's why my boss feels that I can be useful in Tennessee.
How long have you been with Mr. Singleton, or the Singleton firm?
It'll be since 2015, October of 2015.
So you began that shortly after closing or leaving the other? You received your Tennessee Funeral Director's License this year, is that correct?
Yes. Trying to apply for a funeral director in embalming when I registered on the computer, but somehow it overlapped with the commerce, So I was trying to work with them, and since March, to get this application and get my license in Tennessee.
His embalmer application was pending when his funeral director license was issued, but because he didn't have the educational requirements for the embalmer, and it falls back to the reciprocity statute, which the board reviews all those, so that's why we couldn't issue his embalmer license at the time. We had communicated with him about coming to the August board meeting, and that was when it was first presented to the board, and the board tabled it to the next meeting, which this is the next meeting since the August meeting.
And the reason we tabled that was the fact that Mr. Gullett was not present, is that correct?
He was not present, and there was question about the 24 hours. And, you know, that you asked him about there a while ago, and he explained he meant to put 24/7. 24 hours a day, 7 days a week, I guess, is what you intended to.
And the reason you were not able to meet at the last meeting, Mr. Gullett?
I was working at the time.
Are you working now?
Oh, yes.
Point of information, there is an affidavit on page 16 in the packet dated October 1st stating that Mr. Gullett is working 40 or more hours per week.
That's since 2015. Is that correct?
Sorry?
You've been working the 40 hours a week since October of 15?
Correct.
For them? Okay.
Just for clarification, was the business that you owned, closed, and sold operated in Kentucky or in Florida?
Kentucky is where I started the establishment. Florida is where I learned my trade after school.
How long did you operate the establishment in Kentucky before closing it?
3 years. Maple Grove Funeral Home. First year, we did about 12 calls. Second year, did 23. And the third year, we did 36.
disciplinary action during that time?
What town was Maple Grove in?
Maplesville,
Okay.
Jessamine County,
Okay.
just south of Lexington.
I see now.
Mr. Gribble, is your office comfortable with this application?
All the documents are in order, and he's complied with all the requests that we've asked him to comply with.
That was my, certainly.
And the only question was about where he had put the 24 hours a week on there. That was the main flag.
That was the question. But even if he'd have put 24/7, I could not have approved it and reviewed it and approved it administratively because it involves the educational requirements and substituting the 5 years, and that's something that the board historically always reviews and approves.
Okay. I will make a motion to grant this application.
Second.
I have a motion by Mr. McKinney, a second by Mr. Bridges. All in favor?
Aye.
Opposed? Congratulations, sir.
Thank you. Thank you.
Yes, the record needs to reflect that Mr. Cochran departed at 12:05. The establishment application, today we have Williams Funeral Home. Proposed manager is Rodney Eric Williams at 5279 Arnold Road in Memphis, Tennessee, 38118-3505. The application is for a change of ownership. The new ownership is to be a limited liability company owned by Williams Funeral Home of Memphis, LLC, 5279 Arnold Road in Memphis, Tennessee, 38118-3505. Mr. Williams is here today. Williams, if you will, introduce yourself to the board and make whatever presentation you'd like to the board.
Good morning. My name is Rodney Williams. I'm a licensed funeral director, licensed embalmer in the state of Tennessee as well as the state of Arkansas. In 2012, I opened up Signature Funeral Services in Memphis, Tennessee. On Night Arnold, that was the first funeral establishment in that area of the city. In 2016, I closed that establishment, proposing to manage a funeral home by the name of Signature Funeral Home by Premier, which is located at 5279 Arnold Road. It is a licensed establishment, and I'm currently independently operating that establishment right now. I put an application in for the Williams Funeral Home because Williams is my family name, and I wanted to get away from the Signature name and to start fresh and new, and that's what I'm here today to try to accomplish.
Mr. Gribble, does Signature Funeral Homes by Premier currently have a license to operate?
They do, sir. It's an active license. Roland, is it Gosey or Gossey? How's his name?
Gosey.
Mr. Roland Gosey is listed as the manager of the firm.
Mr. Mr. Williams, have you purchased this firm, or?
Yes, I'm actively making payments to the previous owners.
You're in the process of buying them out.
Well, the agreement has already been made.
Okay.
I've been operating independently of myself since the 1st of September.
Okay, so I just want to make sure I understand. The funeral home is operating under the previous owner's establishment license?
That is correct.
For a change of ownership and name change today.
I guess my concern is that the fact that they're still operating.
Effectively take over?
Around September the 10th. And I don't believe there's any rules or statutes that prohibit me from a licensed establishment, being that I am a licensed funeral director, and that I did file the necessary paperwork in the appropriate time for those changes. So I'm a licensed funeral director and a licensed embalmer, and the inspector made no comment about me actively operating that business. Doing the reinspection. Yes.
Mr. Gribble, you and Mrs. Hooper, is there any information in regards to Mr. Williams that we do not have in our file?
Well, first I'll say there is a provision in the rules and regulations that has a 75-day window to seek licensure for a change of ownership, and so that's not...
That's not an issue.
Yeah, not necessarily an issue. I think one point that the board may seek clarity on is when operations begin, which license was being operated under. Was Mr. Williams operating under the existing license, or was he operating independently as Williams Funeral Establishment seeking a license? Because there are several open and active complaints against the Signature Funeral Home, and the board authorized a revocation of that establishment license with a set of complaints that were at issue and still are.
And to answer your question, Mr. President, yes, there's some documentation that we had tried to converse with Mr. Gossi about for an explanation. There's a letter that he had sent to us in 2017 that had some information in it that would clearly not indicate that Mr. Williams would be there operating the funeral home, or that they'd be selling to him. From what was contained in that letter, I've tried numerous times and numerous ways to speak with Mr. Gossi and haven't been able to do that. His email that we have, it came back. I went on the website of the funeral home that he owns in Arkansas, sent an email to that email address. It came back as undeliverable, and I've called and left him messages. Whether he got those, I don't know, but he's not responded to them.
I believe the last time Mr. Williams was before the board would have been in June of 2016, and that is the occasion on which he mentioned that he was seeking to become the manager of the existing license holder for that location, Signature Funeral Home. And at that time, I think the board expressed concerns with Mr. Williams being the manager of that location, and the establishment was only approved after they changed their manager to another individual. At that particular meeting, there was a substantive discussion regarding a body that was located in a hearse that was removed from the premises while an inspector was on site, and that was a big point of contention for that particular discussion. To refresh you all's recollection, who were on the board at that time.
And may I say that the board did not take action upon that because I was operating under an active license at that time.
What year was that?
This was in June 2016. It was right when there was an application for this new Signature Funeral Home to take over. It was going to be a new set of owners, and at that time they proposed that Mr. Williams be the establishment manager, and the board had substantive discussions about the incident involving the body located in the hearse being removed from the premises, and ultimately the board would not approve the establishment application until Mr. Williams was removed as the manager and the new individual was put in place.
And I believe that manager was Roland Gosi, and he was like 3 hours away, which led to some of the complaints that led to the council's recommendation that Signature Funeral Home's license be revoked. I wasn't able to get a lot of information on that because when I contacted the board, they would not discuss any information with me prior to the initiation of our transaction. So I didn't have a lot of information on what was going on with the funeral home during that time. I do understand that Roland and Bill Walker wanted to go, and they wanted to put me back in the position I was when they came, which I owned a funeral home that was active and open. I closed it and was not allowed to manage a funeral home for whatever reason. I don't know. I met the requirements, and I met the requirements, and yet I was not allowed to manage that funeral home, which is probably the reason it's in the shape that it's in now.
Just for clarification, Mr. Gribble and Ms. Hooper, as far as the revocation is concerned, what role or what position did Mr. Williams play in that funeral home that the license was revoked?
As far as we're aware, there was a letter submitted to the board office indicating that Mr. Williams would have no involvement with the Signature Funeral Home currently licensed at that location, and so the revocation that was recommended, from what we're aware of, at this time, Mr. Williams was not involved. Any issues involving Mr. Williams occurred prior to 2016, but there are a number of consent orders against Mr. Williams related to violations of the laws and/or rules. And I can provide additional information with that regarding that if the board would like it.
Are they open or closed?
They're all closed.
Okay.
They're consent orders relating to violations, and I only bring those up because while the current conduct that Signature Funeral Home is being held responsible for by the board is not attributable to Mr. Williams, the past conduct could be relevant as the board determines whether or not it wants to grant or deny this establishment license. This board does have the basis to do either. The statute TCA 62-5-317 provides the basis for denying an establishment license, and so in reviewing this application, there is within the history of Mr. Williams' operations of the licensee, there is discretion to deny here in this case, and so information was reviewed considering the substantial amount of history.
And may I also address with the board, in 2016, I had an open licensed establishment that I voluntarily closed in order to be considered as manager for Signature Funeral Home by Premier. And I had served my 62-day suspension. I would be in a facility with a prep room. I have a prep room in this building. Okay? So I just hate that that keeps coming back up because I have a prep room in this facility. Most of the complaints that I have were administratively issued. They were not from families. One may have been from a family, and it wasn't even, I consented on that because I wanted all of this stuff over and done with so I can move on with managing Signature Funeral Home by Premier, which I never received an opportunity to do, even though I met those requirements. I wasn't allowed to keep my funeral home open while that process was going on, and I didn't think that was fair. Because of even Mr. I think the president on the board at the time was managing 2 funeral homes, and I never brought that up. But I just wanted to move forward. I never thought that I would not be able to, that the board would be able to determine me being able to manage a funeral home as a board, telling owners that no, I can't manage a funeral home, but I am duly licensed in the state of Tennessee. Now, once again, my license has just been renewed, and I'm here today. I'm 41 years old. I want a way to take care of my family and myself. I want to get away from the signature name, a name that I created in 2012, and I want to open up Williams Funeral Home, which is my family name. Now, I wouldn't put my family's name on anything that I wanted to bring jeopardy to. I wouldn't want to jeopardize and ruin my name on the basis of something that the board members are bringing up from years and years ago. If people go to jail, people get convicted, they get out, and they move on with their lives. Now, I served my 62-day suspension, and for that to keep coming up over and over again, and even after you have renewed my license 2 terms in a row, we still revert back to Mr. Williams' complaints from such a long time ago. I just want to move on with my life. I've been allowed to go back to where I started, and again, I was the first and only funeral home in that area of the city, by myself, and able to grow my business in that area. That's the area of the city I wish to be in. When in July, when I talked to Roland, and when I talked to Bill, they said we want out, and asked me, do I know, or do I think I'll be able to handle it on my own? And my answer was yes. And from September and until now, I've been able to do so.
Approximately how many families have you served in that time?
6. Well,
I will clarify for
15,
the record.
15 families.
Oh, I'm sorry. I will clarify for the record, the board's discretion is as to the issuance of the establishment, not the managerial responsibilities of the establishment.
But in 2016, it was as to the managerial.
Today, we're discussing the establishment license application, and that's what's before you today. If the board did not approve the establishment application, we would not reach the question of managerial responsibilities. But it's up to the board's discretion. And I think because we've kind of talked about the past in kind of vague terms, we have reviewed the history and can very briefly give the board a rundown of the timelines, the penalties, and when these orders were entered so that the board has all the relevant information. There are a total of 3 consent orders against Mr. Williams directly. One is case number 2010026031, and the facts of that one dealt with refusing to promptly surrender custody of deceased human remains. That resulted in a civil penalty of $1,000, and an order was entered. On December 31st, 2010. The second one, it's case number 2015-01569. The location was not permitted to perform embalming because it did not have a preparation room on site, and the consent order indicates that in 2013 and 2014, embalming was performed on site in the establishment's break room. Also in 2013 and 2014, Mr. Williams admits to using caskets that had previously been used as receptacles or in connection with the burial of dead human bodies. For that one, there was a suspension that Mr. Williams spoke of 62 days of his funeral director and embalmer license, and he could not be on site during that suspension. There was also a civil penalty of $1,000 along with hearing costs of $200 and investigation costs of $425. And that resulted in a total of $1,625 owed. And there was 10 hours of continuing education ordered, including 3 hours of ethics, and that was entered on November 9th of 2015. And then finally, there was another consent order entered, and that was case number 2015-017-252. And I'll just read from those from that particular consent order. So the facts of that were that respondent stated to complainant and to the board investigator that complainant would have to pay $7 out of her remaining $199 balance in order to pick up the death certificate, and that's paragraph 5 on page 3 of the consent order. And then in paragraph 6, respondent charged $735 for receiving remains from another funeral home, which was a charge paid to the first establishment. Respondent's charge for receiving remains from another funeral home on the general price list, however, has a different price, and its explanation does account for this charge. This charge would need to be on another line as a separate item and not listed as receiving remains from another funeral home. And that particular consent order resulted in a civil penalty of $500, and that order was entered on April 8th of 2016. That's the applicant's disciplinary history with the board, and that does not address the penalties against Signature Funeral Home, which at that time the applicant did own and operate.
Mr. Shackleton, you had a question for me?
Yes, Mr. Williams, your agreement with the owners of Signature Funeral Home by Premier, is it in the form of a lease purchase agreement, or have they already transferred title to the assets of that business to you?
I just signed promissory notes and gave them to them.
No assets then, to your knowledge, have been transferred into your name?
The business doesn't have any assets that I didn't own. Most of the stuff in the building was already mine.
They own the actual building and land, or is it leased, or how is that?
The building is leased, and I've made the last 2 payments on the lease.
Not owned by the gentlemen that had been named as the previous owners of the Signature Funeral Home. Is it owned by another party, a third party?
The building, yes, it is owned by another party. Yes, it is. Duff, did you have a question for me?
No.
Okay. You looked at me when
I'm just thinking.
Caskets, and the caskets that were reused were used for veterans that were unclaimed. I didn't want to take air trays out there to bury them in. So the caskets I use for cremation and services, I buried the veterans in those caskets where they would not have otherwise been awarded a casket. That's where that complaint came from.
Williams, what was the effective date of the transfer? When did you take over? In September?
Around September the 10th.
Are there pre-closing requirements for the transfer with this board?
The rule that Ms. Hooper referenced earlier, it's Rule 0660-06-.03, change of ownership. It says, upon a change in ownership, the new owner shall apply for a new establishment license and shall not operate more than 75 days without either issuance of a new license or appearing before the board and obtaining an extension of time. The as Ms. Hooper has alluded to, there are several complaints that are pending against Signature by Premier. And I was going to look under to see if, let me check one other thing.
These previous, Ms. Hooper, these previous complaints that you mentioned in 2010, 2015, 13, 14, were those against the licensee or the establishment?
Those are against Rodney Williams. The ones against the establishment were not included in that summary, but there were at least 2 more consent orders that are against the establishment, which Mr. Williams owned and operated at that time.
And I believe those were kind of congruent with the complaints. I mean, when I got fined, my personal licenses and the establishment. You know, so I got hit 3 times for one.
I understand.
Yeah. So yes, that's correct. Okay. The same set of facts can form the basis of.
And we have some outstanding complaints against.
No complaints against me, not at all.
But the establishment.
The outstanding complaints are against the current holder of that license for that location. It would be Signature Funeral Home by Premier and Mr. Gosey and Mr. Bell, and that relates to a number of violations that took place. And as indicated earlier, we don't have any indication that Mr. Williams, who's here today, was involved in those set of acts.
Okay, so the outstanding complaints doesn't have anything to do with Mr. Williams?
As far as we know at this time.
Okay.
And I only say that because Mr. Williams has kind of been in and out as far as owning, operating, managing this particular establishment at this location. As far as what we know of, he's not involved with the existing outstanding complaints against Signature Funeral Home by Premier.
And I can confirm that I'm not involved in any of that. I've been gone almost 2 years.
Just to answer what I was looking for is also Rule 0660-01-.03. Says, in addition to any other requirement of the board's rules or any statute pertaining to the profession of funeral directing or embalming, the following shall be reported in writing to the board by the licensee within 10 days of the effective date of the change. And the first one, A, is a change in ownership of the funeral establishment. That wasn't reported to us by Signature by Premier. And that's why I said earlier, I tried to communicate with Mr. Gosey and have been unsuccessful or unable to do that to see if they assented to the change of ownership. And Mr. Williams produced a document in the last 4 or 5 days that has a signature of Ronald Gosey that's been notarized. Who is the notary that notarized that, Mr. Williams?
Carolyn Williams, that's my mother. But I believe the initial application was submitted by Roland Gosey. He asked for all the files to upload to Tennessee Corps. So would that not be considered?
Or not? I mean, it was submitted. The initial application was submitted to Mr. Williams, submitted to be Williams Funeral Home, correct, Ms. Bohannon?
the change of ownership, all of the information that was needed with the change of ownership, I was asked to get all of that paperwork together. And I tried to submit it. I couldn't submit it, so Roland Gosey had to submit it through.
Mr. Gerber, can you clarify your question? I'm sorry.
Do we know who actually submitted the first documents we received regarding this change of ownership?
But we wouldn't exactly know who submitted the documents because it was done through core.tn.gov, so it was under signature by Premier's license number. So whoever had access to that account at that time is the person that submitted it. Those documents that we received, of course, that's what Mr. But we didn't, we needed an amended application with the signature of the seller, and that's why he provided that second document.
Because first there was an application for an initial establishment license, and we communicated to Mr. Williams we couldn't issue another establishment license to the same location. And then there was discussion about a change of name, and so then it delved deeper into whether it was actually a change of name or a change of ownership. And it appears it's truly a change of ownership and not a change of name.
That's correct. Initially, when Mr. Williams submitted the application, I contacted him and spoke to him about submitting an application online. And then after that, he actually submitted the new application. And then there was some conversation between him and myself concerning what type of application they were trying to make, if it was a change of ownership or an initial. And that's when clarification was needed as far as if they were selling and he was buying. And that's also, I think, where it came in with Mr. Gribble was wanting clarification from Mr. Gosey as far as the selling of the establishment.
On the documentation, does it not say who submitted the application or whose profile it came from on the application?
Through core.tn.gov, it's who's ever started that account for signature by Premier. So it could be him. Sometimes we have, and I'm sure everybody here has their own account. I just can't say for certain who submitted the application. It's signature by Premier's account, so I would say.
Yeah, I don't have on mine. I don't have any affiliation with any funeral home on my Tennessee core. I don't have any funeral home affiliation on that.
And I will.
And I even called to try to see if I could submit those papers, and I couldn't submit the papers. The paperwork had to be submitted by whoever had that access.
I will state that the document that was received a couple of days ago, as Mr. Gribble stated, does indicate that the current owner or owners assents to this change of ownership. Of course, the board office can't speculate as to who submitted an online application. If there's no affirmative communication from that individual, it'd be a pure speculation outside of the clear indication that it came from a certain account, which individual actually submitted it, and that's very speculative. In these types of transactions, paperwork is submitted typically to show who is doing what. If somebody's changing ownership, the seller will submit something saying that they're, transferring the establishment to another individual, so we don't have to rely on technological evidence to try to see what somebody's intentions are. That's not typically how things are done with this board. So they did go ahead and submit a document following Mr. Grimble providing a written communication to them indicating that this is a change of ownership, so on and so forth, and it purports to be signed by Mr. Roland Gosey.
Mr. Mr. Williams did send us a letter on September the 10th. It's in your file, probably about page. Yes, where he's referencing the change of ownership on behalf of himself. So he did notify us on September the 10th, which would have been about the day that you assumed operation.
Yes, sir. Those I emailed all of that to Roland, and then he I guess he.
Firm have pre-need funerals in force?
No, sir. No.
Williams, going back to the caskets that you alluded to earlier that were used for veterans, unclaimed veterans, I believe you said. And this question really doesn't have a bearing on the application of the statute that covers that, but it might give us some insight into your thoughts at the time. Were those caskets donated to those unclaimed veterans and you did not receive any payment for those caskets, or did you charge for those caskets and you were compensated for those caskets?
I think we determined the last time that I did receive payment, but payment for services and not for the caskets. They were.
Did not have any charges on your statement of goods and services for merchandise in
If
the
I
form
could,
of a
no,
casket?
not for unclaimed veterans. I believe the person who was in the VA, they just had I think they would call different funeral homes to see if we were able to do an unclaimed. And in some instances where in those instances, then we provided everything we needed to do. In instances where a person may have died in a facility that wasn't a VA facility, and there was no next of kin and no guarantee of retrieving any type of payment, I just put them in a casket that we had used for a cremation service and took them to the veteran cemetery.
Safe to say then that the caskets that you reused, you did not receive any compensation for when you reused those caskets?
I didn't receive any. I didn't receive a dime for those. Well, I just wasn't aware that the law states that once a casket has been used, it cannot be buried. You know, that kind of snuck up on me because in Arkansas, it's not really like that. You know, gift a casket in Arkansas, and so I kind of didn't think. I've learned there's a lot of difference, and I've been abreast of a lot of differences in the laws in Arkansas and Tennessee.
Super, do you have that statute at hand that deals with the reuse of?
Yes, I can give you that citation in 1 second. Uh, 625317, section B8. Would you like for me to read that for the record?
Have that available, please.
Okay. I'll read Part B. In addition, the board may refuse to grant or may suspend, revoke, or refuse to renew any license granted for the operation of a funeral establishment or to any funeral director or embalmer under this Chapter 4, and number 8 states, using any casket or part of a casket that has previously been used as a receptacle for or in connection with the burial or other disposition of a dead human body, except the shipping of another dead human body, or where disposition of the dead human body is to be by cremation. It shall be permissible to utilize a previously used casket shell for viewing the remains if and only if a new interior or interior insert is installed prior to each usage of the casket shell.
There I think that was one thing also. Instead of purchasing liners, we would wash the pillow and wash the liner and put it back in the casket. We were supposed to be actually reordering casket interior. So I just purchased a rental unit.
What kind of lining was it that you washed?
Just the crepe over the.
What was the fabric made out of? I've never seen a casket you could wash.
Not the casket, the interior.
I'm talking about the interior.
You have to take it out. You have to take it out, take the foam out, wash it, put it back on like a pillowcase, and put it back in the. Again, since all of this, my licenses have been renewed at least 1 or 2 times prior, following those incidents. I reiterate to the board that anything that I have done, I have paid for, and I again wish to living for my family. If I had a funeral home, I was asked to close that funeral home in an effort to manage another funeral home, and never got a chance to manage that funeral home, which is probably why that funeral home is in the position that it is in now. And most of my complaints were administratively issued. They were either directly filed from the funeral board or in conjunction with another complaint with another funeral home on it.
Does that not throw a red flag up for you? You're asking to have an establishment license?
I had one. You all had just renewed that as well. I was asked to close that establishment to manage Signature Funeral Home by Premier. Deeply enough at the complaints that were filed, you'll see that probably were omission errors when I signed as the notary and the notary signed as the funeral director. And I had to pay $1,600 for that. You know, it's just small things that at the time I could not fight because I had to move forward. I could sit back, I could hold up this board's time, I could hold and run a complaint list days and days out, or I could resolve the issue and move on. In 2016, I wanted to resolve those issues, and I wanted to move on. And I have, to this day, been on a 62-day suspension. From the time I started my suspension until right now, it just keeps coming back. Not a different board, the same board. It just keeps coming back up. So I'll never be able to forget those mistakes every time I come before this board. If I decide to open up another funeral home, am I going to have to come through and go through all of these complaints again? Is my past going to continuously haunt me, or am I going to be able to start over fresh? Made whole. I want to be my own business back. I want to be able to provide a living for my family. License was just renewed this year. None of these issues were brought up when I sent my license in for renewal, which makes me a duly licensed funeral director in the state of Tennessee. A licensed embalmer in the state of Tennessee, wanting to open up a funeral home that's burying 60 bodies a year.
Now, I don't think that renewing the license is any specific indication of what has been talked about here today is the disciplinary history against this individual. And the license has been renewed each time. So the renewal of the license is no specific indication of stamp of approval. I mean, Mr. Williams does have a current funeral director. He has a current embalmer's license. He also has the disciplinary history that Ms. Hooper provided to the board. And Mr. Williams, that doesn't change. I mean, it's the discretion of the board to how they want to use that, and to how many years you move from it as to how long it's still relevant or how pertinent it is. That's the discretion of the board.
I haven't repeated anything. I don't have any other violations. I paid my fine. I basically did the crime. I paid the time, and I want to move on. I acknowledged my wrongdoing, but yet and still, when will I have an opportunity to show the board that, hey, I'm older and wiser now. I'm more mature, and I'm able to move forward.
Ms. Hooper, the last civil penalty against Mr. Williams was in 2016. Is that right?
The order was entered on April 8th, 2016, and that was $500. Yes.
Okay, so that was the last one.
Williams, how many employees do you have there at Williams Funeral Home? Employees do you have at your funeral home?
I have 2 people that work at the funeral home right now. I don't see a need for more people at this time.
That listed on this document that was sent in?
Yes.
That's only 2?
Yes.
1 full-time and 1 part-time person?
Correct.
Williams, we certainly don't mean to belabor the history, but we know you understand that we're charged with protecting the consumers in this state. And sometimes all we have to go on is past performance as an indicator of what future performance could possibly be, and that's why we have to weigh these things so carefully and consider them carefully, and unfortunately that's why these things oftentimes keep coming up, is because that's one of the indicators that we have to look at. I was not on the board at the time of these earlier complaints, so this is new. Opposed to this, so I'm having to learn as I go about the situation. But we're certainly not trying to beat you over the head with things that have been a part of your past, but at the same time we must consider those things as our responsibility to protect the consumers in this state.
In doing that, would you please consider the fact that no family was affected with any violation that I made. No one family was affected negatively.
That point, and you mentioned many of these individuals that received, and going back to the caskets that were reused, the merchandise that was reused, made the point that many of those people did not have family members. But in cases where perhaps they did have family members, were those family members made aware of the fact that that casket had been used previously for another person?
No, those caskets were only used for unclaimed veterans.
Survivors that you had to deal with?
I never dealt with anybody but the VA on those cases. If I picked up a body from the VA that was considered to be unclaimed, then the VA provided a way of payment to the funeral home. If I picked up a veteran that may have been at a boarding house or something, or died at home, or otherwise, then I would be responsible for the burial once I had picked that body up. And I believe funeral directors are responsible for burying the veterans anyway if they're unclaimed and there's no family members around. And I would pick up if they called from the group homes or wherever they called from. I would go and pick the body up, and I didn't want to be I just want to take them out there in a air tray. I had 2 or 3 caskets I couldn't bury, and I would award them a casket where they would otherwise not have had one.
I will clarify for the record, the case from 2010, the facts in that dealt with refusing to promptly surrender custody of deceased human remains, and that was a civil penalty of $1,000. And along with that case involving the 62-day suspension, there was performance of embalming in the establishment's break room, as the establishment did not have an authorized preparation room on site. Just for the record, regarding potential consumer harm.
I think we determined in the first meeting, since I have to defend that again, we had an emergency hearing which determined that nothing I did affected the public. So the summary suspension that was proposed never took place because I had the necessary equipment in the funeral home to prevent any public.
Mr. Williams, how many unclaimed veterans have you served?
I have to say off the top of my head, unclaimed about 20-25 over the past since 2012.
Where are you getting the merchandise that you're using? These caskets that you're using for a second time.
Well, I only had 2 or 3 at the time. I only had 2 or 3 caskets at that time.
So are you using new merchandise now?
But you're saying unclaimed veterans. When you say unclaimed veterans, the VA...
Those that you pick up from the VA. The VA calls you and you go pick up. What do you do?
Those, I purchase a casket for those because I'm receiving money.
Tell me what you do from start to finish. Once the VA calls you, what do you do?
Once the VA calls me, they give me the information, give me as much vital information as they can give me, and I schedule the burial at the Veteran Cemetery. Excuse me.
Veteran Cemetery of West Tennessee, is the state cemetery, is that where you bury them? Or you bury them in the National Cemetery, or where do you bury them?
In the West Tennessee State Veteran Cemetery.
Okay. The casket that you use for that, you're saying you purchase those now?
I've always purchased caskets. If it was a case where I wasn't going to get paid for, then I would take a casket that had been used for a cremation service and use that casket. It was prior to me understanding and knowing what the law was here, though.
All right, on those caskets that you used the second time, you said you washed the pillow and you washed the interior out. What did you indicated those caskets were used for cremation? Were they used for viewings or?
Yes, viewing.
Okay.
And then the body taken out and cremated.
Okay. Were they rental type caskets, or were they just traditional caskets that you use?
I would use it would be a traditional casket I would use for a rental.
Does the VA file the death certificate for those individuals?
No, the funeral director does. The VA takes the death certificate to the health department. Yes, they do file those.
Super. The case where the embalming took place in the break room, was their family involved in any of this?
The facts don't indicate that. It just indicates where it took place, that there was no authorized preparation room, and that the break room and the establishment was used to perform the embalming procedures.
And let me just say that it was a place designated on a floor plan to be a break room. It was not used for break room. It was used for storage.
I would submit to the board that allegation was made at the time, or that response was made at the time. The consent order reflects that it was differently, I think. Mr. Williams, do you remember what you told the board that was here in June of 2016 when you came before the board about what your memory and recollection as to what you said about maybe you didn't need to own a funeral home, you didn't need to manage or you didn't need to own a funeral home? What did you tell the board at that time?
I really don't remember what I said, but clearly my thoughts have changed on that.
Help my memory and for the members that weren't on the board at the time. He went to the location, and as I recall, the location had agreed to cease operations. There was a body in the hearse, and at least a couple of burials happened after they had agreed to cease operations. Did you recall that?
What I recall, Mr. Bridges, is that the inspector was there to do an inspection. The hearse was parked. It appears it had a deceased human remains in it that was in a casket that had been sitting there for some period of time on the outside. And there was nobody, if my memory is correct, is Mr. Williams and the inspector there, and they go inside the funeral home for very few minutes, and when they came back out, the hearse was gone with the body. That's what and truly there was no disciplinary action on this. He said they were, because of what happened that day, there was no complaint initiated based upon that because of what happened at the board meeting in 2016.
Which was the license was still listed as active and open, and the day following that.
My sentiments would concur with Mr. Shackelford's and what he said a few minutes ago. We're not trying to beat you up. We're just charged with a great responsibility. And what I look at and what worries me about this complaint is, and I was here in 2010, but not for the rest of the complaints. But you've got 2010, 2013, 2014, 2015, 2016, and I would have an easier time letting you move on, so to speak, if you could go a while longer without complaints. Because I'm for second chances, but I'd like to see you go a while, without complaints against you.
So you just want me to keep on paying rent and utilities, and until the board decides that I can move forward. That's your consensus.
Well,
because right now I'm financially vested.
The board hadn't made its mind up yet. I mean, this application's open. I'm just thinking out loud for you. That's what worries me. Is all these complaints, and we don't want to grant you a license and then you be a perpetual
well, we live and we learn. We live and we learn, but one thing we don't do is mistreat families. One thing we don't do is mistreat families. We live and we learn. We make our mistakes, but we don't mistreat families. There is no evidence that I've ever mistreated a consumer.
Mr. Williams, as a parent, a lot of times your children get into things that you don't approve of, and they indicate to you that that'll never happen again. But until time passes and they prove themselves, there is that speculation. And that's where we are. That time just hadn't passed yet, in my opinion. And there is some speculation because of your history that you have the qualifications to run an establishment. My opinion.
Ms. Hooper, is there any room here for us to give consideration to some type of a probationary licensure period? See that having any application in this particular situation. I know in the past of one instance where we have done that, but it started out as a partial establishment license, as I recall, and then we made it a full establishment license and continued a probationary period where we would have the right to immediately revoke that license should they violate the terms of that probation. Does that have any application in a situation like this, in your opinion?
I would like to know the answer to that, too.
The board has done this, as you indicated, Mr. Shackelford, once in the past that I'm aware of, and the board has the discretion to use that option if it so chooses, and to stipulate the parameters of that probationary period, along with whether or not the board wants to limit the scope of the activities that can occur for any time period as well, as long as the applicant so agrees.
The office or legal department may not prefer that. Maybe some of the other board members may not prefer that option.
It is an
but
option.
It isn't. But it in my mind, it is. It's an option.
Address the issue that you raised about a period of time where there are no violations.
Actions, yeah.
I actually be comfortable with that if it includes only those items right there. That those items that are repetitive items in every hearing that I come to, or every meeting that I come to that I keep on hearing, that keep nailing me to the cross. If those are included in that stipulation, then I'm not opposed to that.
What I think what we've done in the past is, if we grant the license the license would have a probation period of, a year or 2 years, and with the understanding that we expect, we expect no infractions during that time. And if after the probation period there's been no violations, then, probation's lifted and you're good to go. But you would have to, agree, to the terms of the probation. So, I mean, it's not only in our hands. I mean, it's whatever you would agree to.
I would only agree to that if it includes only those items that have been brought up today. Because anything could happen. It can happen to you. Somebody can come in. You can send a body out, and you could have somebody embalm and get to the church and have fluid all over the chest, and then so things like that could happen. So that's like playing Russian roulette. Now, if it's something I've already done, then I don't mind that. I don't mind agreeing to that. I don't mind mind not embalming in the break room. I don't mind agreeing to not reuse. I don't mind not. So if that's the case, then I'll totally agree to that. But I'm just not a person that's gonna habitually get out and abuse the law and the rules and the regulations. That's not me. That's never been me. Anything that's been before this board has been either misunderstood or me signing in the wrong place. There has never been a complaint from a consumer to this board. My first complaint came from Robert Gribble. I was trying to get a body to all day, but I didn't want to sit down and have a hearing about it. I wanted it out the way. Christian funeral directors paid $1,000 for whole. Now, when somebody called me to pick a body up, I'd take it to them. From that, everything, a complaint was filed on another funeral home, and I was co-mingled in that complaint because I signed what a notary is supposed to sign, and a funeral director signed. Notary signed what a funeral director signs. On an insurance assignment, I was told that I was allowing people to funeral direct when I sent an email from my office to the front office instructing them to have them to fill out a claim form on insurance. I was made to close a funeral home that I would probably still have open today to manage a funeral home that I never got a chance to manage. The only thing I'm asking this board is to put me back in the same position I was in when I came in here to apply as a manager of that funeral home.
All right, Mr. Williams, I think we have heard, of course, that numerous times today, and I think we don't want to belabor all of that information. Are there any other questions from the board?
Mr. Williams, who made you close that funeral home? You've alluded to that, but I never understood who it was that actually made you close that funeral home.
I was told that by Mr. Gribble that I had to close that funeral home before applying for another license. At the time, Mr. Helms, he managed 2 funeral homes in Jackson, Tennessee. I had to close that to do this. It's like I had to close my business, and I really feel like the board never intended to allow me to move on.
Board members, I would disagree with his last statement there. There was a lot of emails went back and forth. Mr. Williams closed that business because he was going to go do the other one, as I recall. I did not direct him to. I did not tell him he had to. It was an option that he brought up. It's something he did.
I was told that I had to close it to open that funeral home up. And I was real at the very last minute skeptical about doing that because I was skeptical about what happening. And what I was skeptical left me in a terrible financial situation, no job, and no business, and no. That's why I was back and forth on the emails. But I was instructed that, just like this right here, when I put an initial application in, just to see, how the Tennessee court works, I got an immediate call saying that, they need to close that funeral home before you can do an initial application. So I started asking questions at that point. Okay, how when we started discussing how I could transition into this business, then I started asking questions because I didn't want to be in the situation I was in last time.
Cooper, did you have something else to add, Mr. Williams?
No,
I didn't
sir.
mean to interrupt you. Mr. Cooper, now that Mr. Williams has submitted the application, where do we stand now as far as any applicable time limits before we decide on the status of that application? And where I'm going with that, do we have the time to work on a probationary agreement? Can Mr. Williams continue to operate as he has been operating up to the present time while we work on the details of a probationary agreement? And if it is satisfactory to this board, then we submit it to Mr. Williams and see if it is satisfactory to him. And ultimately, hopefully, we reach an agreement that everybody can live with.
Mr. Williams stated he started operating on September 1st, and the rule permits 75 days. I can look that up. I think the concern with
September 10th.
Okay, September 1st was also stated today. I think the concern is with the proposed limitations to the exact violations that Mr. Williams has already had, as protecting the public includes all the laws, rules, and regulations, and there could be other serious violations that were not committed exactly before, but they could potentially be just as serious or more serious. And so I think the concern is crafting an agreement that only includes the exact violations that have already been committed, and kind of the optics of doing something along those lines. As this board has indicated, there are a number of consent orders and a number of varied violations here, not just one or two types of violations here. And so I think that would be the concern from legal standpoint with entering this type of agreement, the proposed limitations.
Williams, I'm not speaking on behalf of the board. I'm speaking strictly on my own behalf, but I want to ask you a question, and the board may squelch this. This may not go anywhere. This is just a question for consideration and discussion today. If a violation was brought against you that was outside the scope of these violations that have already been committed, that we've already addressed today, that you said you were comfortable with, including those in the probationary agreement, if a different type of violation surfaced and the board determined that there was a reason to take action on that violation, sometimes there's a recommendation from legal counsel that we take no action because the violation either cannot be satisfactorily proven, or there may be a variety of factors that would cause the legal counsel to advise us to close without taking any action. Then other times it is determined that action needs to be taken, and legal may make a recommendation to us for a civil penalty or a formal hearing or other types of actions, letter of warning, those types of things. Would you consent to include in a probationary agreement that if a violation of a different nature, separate and apart from what we're talking about here today in the past, came up and it was of a sufficient nature that the board determined it needed to take action against you as a licensee, that could result in the immediate revocation of your establishment license? if it's still within that probationary period.
I'm not comfortable with any probationary period because, again, I've served 62-day suspension, and I paid more money than I had to pay on those fines. That's over with and done with. This is a new day, and I should not go into any new thing under any type of probation.
Then it's all or nothing is what you're saying.
It has to be now. I just have to, I just have to lose everything I got then. We just leave it at that, losing everything I got. Because I just put everything I had in trying to make that happen. So,
Well, again, I agree with Mr. Shackelford's comments. But I think there may be. Sounds like there's a little lack of trust.
I don't trust the board. I don't trust the funeral board.
Okay.
And I don't do it because I have been fined 3 times for one thing: funeral director embalming. And just because I own the business, you hit me 3 times. But major corporations, you hit 1 time, and the amount you charge me is horrendous. The amount you charge them is little. A man forged a death certificate, a doctor's name on a death certificate, and got fined $200. I signed in the wrong place, and I get fined $2,500. I'm afraid of that. I'm very afraid of that.
Well, you can be assured. I don't. We don't know each other, but I can assure you that I want to see you do well. I want to see your business prosper, but I also want to see you not have any complaints with the board. And there's funeral homes that for years and years and years, that's never had a complaint with this board. So don't think that just because don't think that we're going to be out to get you over some little minor clerical error. And I can think of a bunch.
But for one, I just paid $2,500 for a clerical error. That frightens me. I'm dead serious. That scares me to death.
I would have to kind of interject and say I've not located a consent order in Mr. Williams' name for $2,500 for signing in the wrong place. I've made the board aware of the consent orders that I was able to locate in the legal division. So not sure what consent order Mr. Williams is referring to or whose specific name it was in. I think if he's, stating these facts and making this case that somehow he's been targeted, I think we would need additional information to either substantiate or rebut what he's saying that the board has done here. I will say, as I've said in the past, these consent orders, I think one of these did go to a hearing. I think
I've never had a hearing.
There were hearing costs assessed in one of these, but I think the thing to point out is that with these consent orders and things, the respondent is agreeing to the facts stipulated therein, and it's difficult for the board when respondents later come back and kind of reframe the facts of those particular consent orders. It's challenging because a lot of times, for example, I was not in my current role until 2016 after many of these things happened, and the facts and such are indicated in the documentation of what happened and what was agreed to. So it's difficult when these things are reframed and these types of allegations are made suggesting some type of misconduct on behalf of the board or the board office.
Again, and I'll say this for the record, in 2016 I had a funeral home that was not under probation. I wasn't under probation in 2012. In 2016, I had just served my 62-day suspension. I'm not sure how many people in the state of Tennessee has ever served a 62-day suspension, but I had a 62-day suspension. I had bold letters and underlined words in my consent order. I'm not sure how many people in Tennessee has had that. I was told by the president of the board at that time, Robert Hams, that I couldn't manage two funeral homes, but he managed two funeral homes. So do you understand, Mr. McKinney, my position? And you all wanted me to throw me in an instant probation when in 2016, when I came here to manage a funeral home and not own one, close one because I was told I had to close it. Because I was back and forth with Mr. Gribble about not wanting to close it or not having to close it, and not wanting to close it because I didn't know what was about to happen. I'm a very straight, direct, and to the point person, and I knew I was going to be here all day today.
Well, in my mind, right now, and it seems like in the other board members, some of them haven't spoken to this, but where they agree or disagree. But it seems like, in my mind, we're trying, at least two of us here, are trying to get you a license where you can operate, but under a probation period. And in my feeble mind, right now I have two choices. Either we approve this with a probation period of a year or 2 years, with pretty strict standards laid out, or we deny the application. That's just me.
And might I say, I hadn't said much to this fact, but as Mr. McKinney said, we're trying to help all we can. But at the same time, you're saying that you don't trust us.
Well, I'm going to tell you this right here.
So I have a problem with that.
And I apologize that you have a problem with me not being able to trust. But my first complaint, I spent all day trying to get a body to a funeral director. And I ended up at the end of the day paying a $1,000 fine for being charged with holding the body because somebody would not leave with the body. So how can I prove that? How can I defend myself when the complaint came from the executive secretary? That's the first complaint.
And I think the issue that I spoke to just a few moments ago is essentially kind of relitigating the merits of something that it has already been decided upon. A consent order's been entered. Mr. Williams has agreed to certain facts, and then to have those facts kind of be challenged on the most basic level, it's kind of difficult to go back over those facts and say what really happened. As it stands, Mr. Williams agreed to certain violations of the law and agreed to a certain penalty for such. From legal's perspective, that's where these cases stand.
And I have served the penalty that was imposed upon me and paid the money that was imposed upon me. Now, my only request to this board is to put me back in the position I was in 2016. I had a funeral home. It was not under probation. There were no complaints. And I was able to do business. I wish to operate under Signature Funeral Home by Premier.
Mr. Williams, I have no ill feelings toward you or anything. If I was a complainant, and I don't remember whether the board was or not, if I, in my official capacity, was a complainant, it was because we called, because we'd have no idea. I mean, it was because we was called about the complaint. Someone complained to us. I would have no knowledge of what happened in Memphis and me being in Nashville unless we were notified. And I don't remember being the complainant.
I asked one question. Are we not considered professional funeral directors? And you said, Mr. Williams? I didn't know who you were. I seen you one. I don't even know if you were here when I first got here. I think Mr. Bill T. I didn't know who you were, so to speak, but I know my first complaint, and I remember that. That's neither here or there. What I'm here to do today is try to be restored back to where I was. My own business, and I was operating not under probation. I had served a 62-day suspension. And I was banned from going into my own business. I could not walk into my business and conduct any type of business for 62 days. I had to stay at home. I had to go fishing. I had to get away and trust people who stole from me, who ran bills up, who practically forced me to have to bring somebody else in to keep me going because this board told me I couldn't go in my own funeral and conduct business.
I'll have to.
What was the 62-day suspension for again?
That was the one where in 2013 and 2014 the caskets were being reused, and then the embalming occurred in the break room. That was pretty much that one. The reason we're discussing all this, as I indicated earlier, is that the board does have the discretion to either grant or deny. Because of this history, there are several bases to deny this application under 62-5-317, and that would be B8, which deals with casket, B9, willful violation of any state law or municipal or county ordinance or regulation affecting the handling or custody, care, or transportation of dead human bodies. B11, unreasonably refusing to promptly surrender custody of body upon the express order of the person lawfully entitled to the custody of the dead human body, and B17, failing to comply with any provisions of this chapter or any rule or regulation promulgated or adopted by the board. So the board has these bases to deny the application. The board could also grant the application, and the board also has the option of doing an application on probationary terms. I have taken a look back at the agreed order that was previously done on the one occasion that I can recall, and that order does have some language, and it states that it deals with material violations of any laws and rules, and it excludes minor violations for which the board would not ordinarily impose discipline upon a licensee. I think the board's concern is that the board would like full authority to enforce its laws and rules and have the ability to take action on this license in this probationary period, and that Mr. Williams seeks to limit the board's ability to enforce its laws and rules in this probationary period to the violations that he's already done thus far. And as I expressed earlier, that is somewhat problematic from the perspective of there being any number of laws and rules that could be violated that could be just as or more serious than what has been done in the past. And so I think at this point the board kind of has a great awareness of what options are available to it and has heard from Mr. Williams. So further questions from me, I'm happy to answer or do any further research that you all need to help you reach a decision.
And let me just say, those same things, the board had the right to refuse or revoke or what have you. They had the opportunity to do it when my license was just renewed this past term, and they had the same option to do the same thing the term before that. Those have nothing to do with me moving forward, and this application is to allow me to be able to one, provide for my family.
All right, Mr. Williams, we appreciate your statements today. At this time, it will be a decision that the board will need to take up. I know several things have been discussed, from probationary time frames, of which Mr. Williams is not open to. So certainly the floor is open for discussion among the board.
Okay. Just let me be perfectly clear for the record. I am willing to grant this license with a probation period I'd say of 2 years, with just as strict of requirements as we had on the one, maybe, has it been a year ago or so. I am perfectly willing to do that in order to get this gentleman his license and get him in business. where he can provide for his family. And if he is not willing to do that, then my thought is just to deny the license, because I'm trying to meet him halfway.
All we're asking, Mr. Williams, is that you abide by the law. It's that simple.
It's my intention.
We're just asking that you abide by the law.
And it is my intention to do that. But I'm really afraid that being set up.
Someone brings a frivolous complaint against you, obviously no one can prohibit that from happening, just like I could sue anyone in this room if I chose to. But the courts would have to then determine whether or not my lawsuit had any merit or whether or not it was a frivolous lawsuit. And the same would be such with a complaint that might be filed against you. This board's responsibility then would be to determine whether it was a legitimate complaint or whether it was a frivolous complaint, and then action would be taken or not taken accordingly. So this probationary period is nothing more than asking you to abide by the law. And I assure you this board is not out to get you or anyone else.
Why 24 months?
Well, I think and I don't mean to speak for Mr. McKinney, but I think he cited the history earlier, and it seems like about every year there's been a new violation. And I think he's wanting to see you go for a longer period of time without any violations, beyond a year to get out to that 2-year mark. So
that'd be correct.
So 13 months? Even probation is 11 months, 29 days.
McKinney, are you
last
making that
last count I had, 2 years was 24 months.
Are you making that in form of a motion?
Well, right now I'm letting y'all know my thoughts. And I appreciate whatever Mr. Bridges, Mr. Duffer, and Mr. Davis have to say. Whatever, what's on your mind.
I'd like to say that I just don't think, Mr. Williams, that you take all the previous actions as seriously as you should. I don't believe you are. Sorry, they were serious to the point of suspension, and now you're asking us to just wave them away and start all over, and that can't be done. I think everyone on this committee is concerned that we're going to be back here a year from now. Further to Mr. McKinney's point, that something's been happening every year, and I personally do not support a provisional license, a probationary license.
Mr. Williams, if you truly want to serve families, and if the motion came on forward, granting you that license with that probation period of 2 years, that would enable you to serve families, and that's what you're here for, correct? My question then to Ms. Hooper, if that motion is passed, then he has the right to deny it, come back from the board. What was the procedure?
I think what you all would need to do is get a verbal agreement from Mr. Williams that he's agreeable to that prior to making such a motion, if that's the route you all would like to take. I don't think it would be proper to make that motion without him agreeing to such, because he'd have to agree to a provisional license for that probationary period in order for that to be in place.
That is one possibility here today, I think, from what I'm understanding and hearing. Is that something that you would be agreeable?
In a court of law, typically, a probationary period is 11 months, 29 days.
Mr. Williams, you're before the funeral board, and what has been mentioned is 24 months. Are you in favor of that or not?
I think it's a long time period to be under probation. Time period.
Are you in favor or not?
I'm not opposed to it, but I would like to be able to kind of work the term of 24 months down. I would like to be able to
Williams, if you are truly, like I said earlier, going to abide by the law and the rules of the funeral board in the state of Tennessee, 2 years will pass by quickly. And I think that's what's being said here. I just need to know, from my personal standpoint, is that would you agree to that?
Williams, from my perspective, this is not a matter of trust. It's a matter of risk. Both of us, yourself as an individual and this group that sit on this board, are both placing ourselves in a position of risk with this type of agreement. It doesn't come down to trust. It comes down to risk. And we have to determine, is it worth the risk to take the step that we're offering you? And then you have to determine, is it worth the risk for me to accept? It's not a matter of trust. You have made today some serious allegations, but you have not furnished any proof of those allegations. And I'm specifically referring to a charge that you made against a former board president. But you have not furnished any proof of that. And to me, that's a serious situation. So, we have to look at those things and figure out how that plays into our determination of the risk factor involved. But I think the board, it may not be unanimous, but I think the board is willing to offer you a probationary license for you to continue serving families and doing the things that you do for a period of 24 months. Legal will draw the agreement and submit it to you, and you'll have an opportunity to review that. And all we're asking you to do is obey the law. We're just asking you to obey the law. And I assure you, this board is not out to get you any more than it's out to get anybody. And if any one member on this board has a violation, they will be called before the board just as you have been. I believe that with all my heart. I don't think this board plays favorites. And that is offensive to me that you would indicate that this board is targeting you or targeting any other individual while letting other people slide. That is an offense to me personally, and I can assure you that I will not do that. My integrity will not allow me to do that, and I don't think anybody on this board will do that. We're just charged with upholding the statutes that have been passed in this state to protect the consumers in the death care industry in the state of Tennessee, and we take that charge very seriously. And that's all we're asking you to do is obey the law.
I would be comfortable with the 2-year probation period, providing
With that taking place, is there a motion?
Okay. I'll make a motion that we approve the application with a 2-year probation period, and legal counsel can draw that up. And anything else in that motion to be clearing?
If you could indicate that you would, it would be an agreed order of license probation. You'd approve the issuance of an agreed order of, you'd approve the issuance of a license upon entry of an agreed order of license probation.
Okay. That sounded good, so I'll also move what she said.
I have a motion by Mr. McKinney.
Second.
I have a second by Mr. Shackford. Ms. Bohannon, would you call the roll?
Sorry. Dennis Bridges.
No.
Mark Cawthorn. Robert Davis. Jeff Duffer.
Yes.
Clark McKinney.
Yes.
Charles Rahm.
No.
Robert Shackelford.
Yes.
Mr. President, we have 4 yes and 2 no. Motion passed.
Mr. Williams, you have your establishment license under those terms.
Thank you.
Took a us a while to get there, but we got there. I'm sure Ms. Hooper will get with Mr. Williams.
Yes, we'll draft the order and send it to Mr. Williams to execute and move forward from there. Thank you.
Thank you. And I would like to personally thank the legal staff and the office staff for the extra work in doing that. I know that's something we don't do very often, but thank you for allowing us to do that.
All right, is there any new business? Hearing none. Motion to adjourn.
Motion.
Second.
Meeting adjourned.
Aye.